Hi, I'm Jonathon Kappy.
And I'm Doreen.
Welcome to Holland Estates. You're listening to episode number 534. How you doing, Doreen?
Good, how are you?
I'm good. We've got an interesting case to deal with today. It is the decision of the Court of Appeal for Ontario in Teixeira and Markgraf. And we'll put up a link in the description. But an interesting issue with respect to gifts and checks and bills of exchange.
That's right.
Something that we can all learn something from, I think. So why don't you give us a brief rundown of the facts of the case?
Well, so the facts in this case have to do with a relationship between neighbors. Teixeira is the neighbor of a lady named Mary Markgraf. Mary Markgraf has since died, which was all part of this proceeding, the issue of what happens when you die after you've written a check to somebody. And so it becomes then a matter against the neighbor and Mary's estate. So it turns out in the facts that this neighbor has known Mary for about 15 years. He's helped her out a lot over the years. He's helped her, maintain her house. He's driven her around. He helps her get groceries. He helps her with the bank. But the trial level actually found that he did all these things without any consideration and without any expectation of payment. But Mary was a very nice lady. She recognized all the stuff that her neighbor has done for her. She left Teixeira a $100,000 gift in her will, and she actually also wrote out a check to Teixeira worth also $100,000 and gave it to her stepson, and she told her stepson to give this check to Teixeira and tell Teixeira to take it to her bank to cash it the next day. And that's what he did, except when he got to the bank told him, "I'm sorry, I have to put this on hold. I have to double check with my client." And the reason why he said that was because there was actually insufficient funds in that particular account that the check was drawn on to satisfy the full $100,000. But Mary did have more than $100,000 in different accounts at that particular branch. But unfortunately, before sort of all that could possibly have been figured out, we don't really know what would have happened if the bank spoke to Mary in time, but Mary died. And then Teixeira went to the estate trustee of Mary's estate and said, "Hey, I have this check for $100,000 that's been returned to me for insufficient funds. I want $100,000 plus $100,000 that I would receive under the will."
Right. So the issue became whether or not this check that was given gratuitously for no consideration, which was a valid check, a bill of exchange given to her, taken to the bank, which wasn't yet cashed, is that enforceable as against her estate?
Correct.
And there were a number of arguments that were raised both at the lower court level and the Court of Appeal. Let's get some of the easy ones out of the way.
Yeah.
All right. The court found, number one, that he had provided all those services to his neighbor as a friendly neighbor. There was no consideration, there was no expectation of payment. This was not a contract.
Right.
All right. So there was no contract to be enforced. The court was not going to find a contract.
But if there had been a contract, then there would be a separate analysis, and that is something you can make a claim against the estate.
Yeah. And we're going to get into in a minute the difference between a contract and a gift. Before we do that, let's just talk about the check itself.
Right.
And the check is governed by the Bills of Exchange Act. And there was an argument made as to whether or not the fact that it's a bill of exchange, it should be valid on its face and it should be enforceable. The court looked at the authorities and said that no. But first of all, a check it's not cash.
No.
Okay? It doesn't have inherent value.
Right.
A check is a direction from the person who signs the check to the bank saying, when this paper is presented, pay this person X amount of money.
From this exact account that's listed on the check itself.
That's right.
Which is part of Teixeira's problem in this case, just because there's insufficient funds in that particular account that the check was drawn from.
Right. So in essence, it's almost like a promise to pay.
Mm-hmm.
If you take this to my bank will give you money. And so as it relates to the Bills of Exchange Act, a gratuitous promise of payment does not become binding at the way the language of the statute works, at the suit of the immediate promisee merely because it is expressed formally in a negotiable instrument. So a check is a promise to pay. Just because you write that promise down on a piece of paper that's called a check does not make it any more enforceable than another promise to pay for no consideration.
Right.
And so the court said, no, I'm not paying it on that. The court actually referred to a 1921 case of Pettit and Gear, which dealt with a similar case of a promissory note, which is just another version of a promise to pay. where a father had given a promissory note to his daughter for no consideration, just natural love and affection. I want you to have this money, I promise to pay, and he died. And the court also held, no, it's a gratuitous promise to pay, it's not enforceable.
Right.
So both checks and promissory notes are not enforceable without consideration.
Right.
We go now to the issue of gift. There are 3 elements that you need for a gift. They are intention on the part of the giftor to make the gift, without consideration or expectation of remuneration. There is the acceptance of the gift by the donee. And the third is a sufficient act of delivery or transfer of the property to complete the transaction.
Right. And then in this case, there was, the court, both at the trial level and the Court of Appeal, found that it failed at the delivery stage because there was insufficient funds in Mary's account. And it comes from the idea that you cannot give what you don't have. And so it was impossible for this gift to be delivered in this particular way. If Mary really wanted to give this gift, she would have had to do more to show that she really intended Teixeira to have this extra $100,000. And unfortunately, just based on circumstances, that didn't happen.
Yeah, and the court, relying upon the Irons decision from 1819, that's a long way back, talks about the difference between a gift and a contract. A contract, by its very nature, is an exchange of promises. I promise to do X, you promise to do Y, we have a bargain, and those promises are enforceable. A gift doesn't work the same way. It's not an enforceable promise until there is an act of delivery. And there are several important functions that delivery performs in the context of a gift. Number one, it's make sure that the person who's gifting really does intend to follow through with that gift. And number two, it actually is tangible proof that the gift was made and intended.
Exactly. And the only reason why there's a test to be followed when it comes to gifts is not to sort of force people to give you things on a voluntary basis. It's actually to prevent the very simple idea that once you give someone something, you can't take it back.
Right. And so for those reasons, the court held that a gift by check is not complete when the check is given. It is only complete when the check has been cashed and has been cleared. You have to physically get the money, not the promise, which is the check itself. It appears to be no doubt that this deceased intended for this neighbor to have this money. It was not an enforceable gift. It hadn't been completed.
That's that for our podcast today.
Yes, we hope that you have a great week. Until next time, I want to thank you for listening. I am Jonathon Kappy.
And I'm Doreen.
Should you have any questions, please email us at webmaster@hollandhull.com or leave us a comment on our blog. Have a great day.
Bye.